Good day, Crime Talk aficionados. It is Sunday, and you know what that means? It is the best of, or a weekly recap of all the top stories conveniently located in one location. That's right here. So I hope you enjoy it. Enjoy the show. We'll see you next time. And remember, the Constitution matters. Pretty big, significant change of circumstance in the Bryan Kohberger case, wouldn't you say? Apparently, the defense didn't quite work out as proposed, but the defense ultimately got what they want. Remember, I've told you in the past, death is different. Ann Taylor said that all along. Death is different. Death is different. And they were pulling out all their, all their shots, so to speak, to try and make the death penalty go away. I kept telling everybody, if you watch the litigation of this case, it's always about the death penalty. The prosecutors usually don't go forward with the death penalty unless they believe they have a very strong case that they can win. But the one unknown normally with a death penalty case is if you get one juror, right, it has to be unanimous for death. And if it doesn't go unanimous for death, you spend all that time going to trial, all those additional resources, all the appeals for the next 30 years. And what do you get? You possibly get no death, right? So a guilty plea is certainty. A guilty plea is certainty for the prosecution. It's also certainty for the defendant, apparently Bryan Kohberger, as it is being reported by many, many news services that he is going to plead guilty. And in exchange for his pleas of guilty, he will be spared the death penalty and that he will get life without the possibility of parole, ladies and gentlemen. Now, obviously, the prosecution has the ultimate decision-making authority in that. But remember, there's 4 families involved, right? You got Madison Mogen's family, Kaylee Gonzalez, Xana Kernodle's family. And apparently the Gonzalez family is not happy. In fact, they have said that they condemned the deal, which spares Kohberger his life. And they said, quote, "We are beyond furious at the state of Idaho." This is according to their own Facebook page. "They," referring to the prosecution, "have failed us. Please give us some time. This was very unexpected." I agree. But remember, ladies and gentlemen, if we go back to the Christopher Watts case, the man that killed his wife, 2 young daughters, and that was also a death penalty case. And remember one day they said, "Oh, there's going to be a hearing scheduled for tomorrow." It wasn't set for a preliminary hearing or something. And I said, "Oh, I bet there's going to be a guilty plea." Now, Frank has reminded me before we came on the air this evening that I apparently said that this is ultimately what will happen. They'll go through, they'll litigate the case. I can't remember exactly when I said it, but it doesn't surprise me because that's the case. It is a death penalty case. The goal in the death penalty case is to avoid the felony conviction. Now, I've said this before, and I'll say it again. I had one case, one death penalty case in my time as a defense attorney, and we were able to convince the district attorney not to go death, but we ultimately went to trial, and, well, they had some pretty well overwhelming evidence. What was there? Oh, that pesky DNA. Ooh, pesky DNA. And I think, I always said at the beginning of this case, the problem for Kohberger in this particular case is the DNA. Everybody said, "Oh, don't worry." Not everybody, but a lot of people said, "Oh, there's nothing to worry about with DNA." And I guarantee you the defense was worried about it. Why do you think the defense tried so hard to get rid of the DNA, right? I told you, look at the motions that are being filed. What evidence are they trying to get rid of? That tells you what the defense perceives as a problem for their case. And some people, "Oh, it doesn't really matter. It's only no, it's his DNA." So ultimately, now, and here's the other thing. Obviously, the prosecution makes this ultimate decision, and normally under most victims' rights acts type of situations, the families should be consulted. But guess what? The family doesn't have the ultimate say as to what the plea disposition will be. They have to be consulted. And I don't know if the prosecutors consulted the Gonsalves family, because apparently the Gonsalves family is quite upset. And they said, it's true. We're beyond furious at the state of Idaho. They failed us. Please give us some time. This was unexpected. We appreciate your love and support. Like I said, I'm not going to say I'm an expert on the Victims' Rights Acts, but the Victim Rights Acts that I've had to deal with in both state and federal court, victims need to be consulted. Doesn't mean that they hold veto power over any plea bargain, because obviously the prosecutor is in the best situation to assess their case. And this provides certainty. I know the Gonsalves family doesn't like it, assuming this all goes through. Now, remember, nothing's done until the judge accepts the plea. And so they're going to come into court, and there's going to be an advisement, a colloquy, an exchange between the judge and Mr. Kohberger. And something important, I hopefully will take place. I hope this takes place. Judge, if you're listening, prosecutors, if you're listening, I hope this takes place. At any sort of guilty plea, there's usually some paperwork that the prosecutor has prepared, defense counsel has reviewed it with their client, and it has the plea agreement, right? Plead guilty to counts 1 through 5, 4 counts of first-degree murder, 1 count of burglary. In exchange for that, prosecution will not pursue the death penalty. Okay? Judge says, is this your understanding of the agreement? No side agreements, no hint, hint, wink, wink, nudge, nudge, that type of situation. Nope. That's it. All right. Then the judge has to explain, do you understand the rights that you have to go to a trial? And a good judge will explain those rights to the defendant, where he's thinking, man, why would I want to give up all these cool rights? They do it particularly in federal court. They're like, man, this is so cool, because if you persist in your plea of not guilty, we're going to have a jury trial here in August. All right? We're going to have a jury trial here in August. And guess what? You're going to get to assist your attorney in selecting a jury. And at a trial, the prosecution always has to prove you guilty. But you're given the presumption of innocence, and that presumption of innocence will remain with you, Mr. Kohberger, unless and until you plead guilty, obviously here, or you go to trial and the prosecution proves the case beyond a reasonable doubt. Now, do you understand, at trial, you get to confront and cross-examine all witnesses that come and testify against you through the assistance of your attorney, obviously. Yep. Do you understand that you don't have to present any evidence in your own defense? It's not your job to prove yourself guilty, but that the prosecution must prove their case beyond a reasonable doubt. Yes, I do. He'll have to respond. The judge will then ask him, do you understand, did you have a right to testify? It's an absolute right. It's a very personal right, individual right, that you can testify or not testify, and it's your decision. Neither your attorneys, the prosecutor, the judge, family, nobody can convince you to testify. And you don't have to make that decision until you've heard all of the evidence in this particular case. Do you understand that? Yes, I do. And I'll say, do you understand that the rights that you have, except for your right to an attorney, which will continue through sentencing, you give up all of those rights other than your right to attorney if you plead guilty. So all those motions that you filed and all those potential appellate issues, they all go away. Do you understand that? Do you understand there'll be no jury? There'll be no making the prosecution prove their case beyond a reasonable doubt. Do you understand that no witnesses will come and testify? Do you understand no evidence will have to be presented? You're not going to have to make a decision whether you present a defense or not, whether you testify or not, because all that's going away if the judge accepts his guilty plea. And it has to be a knowing voluntary waiver. So the judge will inquire and say, are you under the influence of any drugs, alcohol, or medication? No, I am not. Are you thinking clearly here today? You heard the plea agreement. Do you understand what the plea agreement means? Do you have any questions? Have you had enough time to talk with your attorney about the proposed plea agreement? Are you satisfied with the advice and representation of your attorney? And that's one of those kind of speak now or forever hold your peace thing, but they always try to attack it anyway. And he'll presumably say, yes, I am. Now, this is before I get to the good stuff, the judge will also say, you understand the maximum penalty here. Do you understand the maximum penalty, which is life without the possibility of parole, probably be consecutive, plus throw in that burglary charge, and there you go, right? Judge says, yep, I understand it. You understand you're never getting out of prison. Unless, of course, the law changes, the legislature changes their mind and says, people that commit quadruple homicides, they just having a bad day. Let's let you out after, 30 years or something. Going to prison for the rest of your life. Okay. Then the judge will do, and I hope this Judge Hippler, does this. I really hope he does this. They should have done this in the Chris Watts case that was just up the road here in Weld County years ago. The judge says, how do you plead guilty? Do you waive a factual basis? Yes or no? What the judge should have Bryan Kohberger do, stated on the record, is tell me in your own words what you did, right? Go through each and every one of them. You were charged with the killing of Madison Mogen. Tell me in your own words how you killed her. Judge says, okay, fine. I'll accept the plea as to Madison Mogen. And then he hopefully will say, tell me in your own words what you did to cause the death of Kayla Gonzalez. How about Xana Kernodle? And go through it. And Ethan Chapin. Boom, boom, boom. And have him state on the record that you did this. You. And that you acted alone. I don't know if we'll ever get a reason out of him. I really don't. Because there's really not, you can take a plea. Victims get to testify. The victims' families get to testify. How this has impacted them. Doesn't make a hill of beans of difference. He's going to get the mandatory life without the possibility of parole. Right? Like I said, this is all assuming the plea goes forward, ladies and gentlemen. It's all assuming the plea goes forward. Next on the docket, Barry Morphew, indicted for the murder of his wife, Suzanne, appeared for the first time on a new murder charge in Colorado today, where the court reiterated that the proceedings can be recorded by the news, but with some limitations. Now, we intended to bring you this proceeding, but we can't. Colorado, unless the court approves some sort of live streaming, you can watch it, but I can't send it to you. And I don't want Frank to be held in contempt. And I don't want to be held in contempt. And I don't want to lose my law license. I mean, I love you all. I do. But I don't make enough money to jeopardize my law license to stream Barry Morphew's court proceeding. All right. I think down the road, though, we'll get some permission to do so. But the reality of it is, just can't do it right now. I love you. I do. Like I said, I've never been a client worth going to jail for, and I've never been paid enough money to jeopardize my law license. And don't get me wrong, I've got a number, but it hasn't been met by anybody yet. And I don't think I'm going to make it on this podcast. All right. So after a brief appearance in Alamosa, a lovely town indeed, I just did a murder trial over there 2 years ago. It was fun, I must say, and it's more fun when you win, because we did. The only bad thing was I had to sue my client to get my final bill paid. It's always a little frustrating. Don't you hate it when clients say, hey, you just walked me on a homicide case where I was going to spend the rest of my life in prison, but I was looking at your final bill and I think you spent a little too much time preparing. Okay, pay my bill or I'm going to sue you. Anyway, I got paid. Let's just put it that way. So Alamosa, for those who do not know, is about 200 miles southwest of Denver. And that marked the beginning of a do-over of the high-profile made-for true crime case. That's right. The disappearance of Suzanne Morphew on Mother's Day back in 2020 spawned numerous documentaries, YouTube shows, and podcasts. And Barry Morphew was present in court in custody today wearing a white and orange striped jail jumpsuit. Those always look so good. So it's Morphew's second time facing a murder charge in this case. The media's interest helped lead to the downfall of the last prosecutor after Barry Morphew was first charged with murder of his wife back in 2021. The former 11th Judicial District Attorney, Linda Stanley, a frequent guest on those true crime shows, eventually lost her law license, partly because of statements that she made about the case during the appearances on some of those podcast. Now, the previous murder charge against Morphew was dropped without prejudice, which means they could file them within the statute of limitations period. But yes, that's right. There is no statute of limitations for first-degree murder, so it allowed the case to be refiled. Then Suzanne remains were found in 2023 in a shallow grave 40 miles from her home, and a 2024 autopsy detected tranquilizer chemicals that Barry Morphew admitted using in the past to sedate wildlife. Now, Morphew's attorney filed an objection to the judge's order allowing media recording of the case, and they argued that the public has a general right to observe trials, but there is no right to televise or record the trials. But the judge in the case, Amanda Hopkins, had previously issued an order allowing news media recording of the case in a preemptive order on June 20th, the day the indictment was unsealed against Mr. Morphew. Now, Hopkins said in court today that recording must be limited to this case and not disrupt other trials and hearings not related to the Morphew case. The public is not allowed to record or rebroadcast the proceedings. Otherwise, you can be held in contempt. I don't want to be going to jail. Otherwise, we do it. I don't want Frank going to jail. You know, he's got young kids. We can't have that. So, one of Morphew's attorneys is Jane Fisher Breislin. She is a member on the Corey Wise Innocence Project, and she wrote in her court filing that pervasive and prejudicial coverage erodes Mr. Morphew's right to the presumption of innocence, to due process, and to a fair trial. But Morphew's attorneys admitted that the argument was now moot since the judge had already granted approval for media access. They were objecting to object. Anyway, the next hearing is set for a status conference to check in on the case for September 2nd. That's basically to see how much time are we going to need. You know, has everybody gotten up to speed yet? I mean, here we are, July, all of July, August, 60 days to get up to speed on a homicide trial. Not too bad if you have no other cases, but yeah, maybe they'll get one more continuance. Then they can proceed to arraignment. And guess what? Mr. Beller, David Beller, told the court that they are going to ask for a reduction of the $3 million bond in the case at the next court appearance. But in the meantime, that's right, Mr. Morphew will remain in custody at the Alamosa County Jail. A fine institution indeed, ladies and gentlemen. Been there many, many times myself. I love going to the Western Slope. And it's a quick little flight. You know, Alamosa is the gateway to Telluride, ladies and gentlemen. Beautiful airport, big runways. Telluride, the airport is up on a plateau, short runway, only one way in, one way out. Alamosa, gateway to Telluride. Remember that, ladies and gentlemen. That's right. The guilty plea for Bryan Kohberger. That's right. He pled guilty to 4 counts of murder and 1 count of burglary in the death of the University of Idaho students, Ethan Chapin, Kaylee Gonzalez, Xana Kernodle, and Madison Mogan. Now, the plea deal, which was reached with the Latah County prosecutors, was approved by Judge Stephen Hippler during a hearing at the courthouse there in Ada County and in Boise specifically. Now, under the terms of the plea agreement, Kohberger will avoid the death penalty and instead face life in prison without the possibility of parole. And he also waived his right to appeal the conviction or seek any type of sentence reduction in the future. Now, for those who don't know or are not familiar with this case, back in November 13th of 2022, Kohberger, and we can now say Kohberger entered the residence at 1122 King Road in Moscow, Idaho, through a sliding kitchen door. Prosecutors detailed that he first went to the 3rd floor where he fatally stabbed Madison Mogan and Kaylee Gonzalez. DNA evidence from the K-bar knife sheath was found near Gonzalez, linked Kohberger to the crime. He then proceeded to the 2nd floor where he killed Xana Kernodle and Ethan Chapin. Now, Kohberger's phone pinged cell towers near the residence, and his white Hyundai Elantra was observed circling and parking behind the house. A surviving roommate reported seeing a figure dressed in black leaving the scene about 4 a.m., and Kohberger's vehicle was later seen speeding away from the area. Now, during the guilty plea, Kohberger confirmed his guilt by responding yes when asked if he willfully murdered each victim. He showed no visible emotion, maintaining a stoic demeanor as he answered the judge's questions and listened to the prosecutor, Bill Thompson, outline the timeline and lay out the factual basis for the murders. Now, the victim's family displayed profound grief and was some visibly shaken and others weeping. The prosecutor, Thompson himself, became emotional, choking up while reading the victims' names and recounting the events of the evening. Now, sentencing is scheduled for 2 days to begin on July 23rd of 2025, although both parties believe it'll probably be done in 1 day, and the victims' families will then have an opportunity to deliver their victim impact statements. Now, the plea deal ensures that Kohberger will spend the rest of his life in prison without parole, a decision that has sparked mixed reactions, while the Mogan and Chapin families expressed support for the deal, citing closure and the avoidance of a prolonged trial. The Gonzalez and Kernodle families opposed it, arguing it denied justice by sparing Kohberger the death penalty. Public reaction has also been quite divided, with some expressing outrage that the prosecutors even extended the offer. Now, we brought it to you live and we gave you the comments at the end. The judge went through everything. He explained the rights that Kohberger has, the rights he gave up, and the possible penalties. He agreed to the factual basis. I will look forward to the actual factual basis that is filed with the plea agreement and the guilty plea paperwork, often referred to as the Rule 11 paperwork, to see if there's any more detail that was not in the prosecutor's, Bill Thompson's, recitation of their factual basis of what they believe the evidence would show. But listen, this case is now essentially over, other than the sentencing, and Kohberger doesn't have to say anything. The victims' families will certainly say something, but I expect Kohberger to say nothing. He doesn't have to give a statement in allocution. He doesn't have to provide any reason why he did it. But the fact of the matter is he pled guilty today, and he confessed to committing the quadruple homicide and burglary at that King Road residence, killing 4 young people. Now, there's a lot of people out there that are still just shocked that Kohberger would plead guilty, but he did. He did it because he knew he was going to lose. That's why he pled guilty, ladies and gentlemen. Prosecutors had him over the barrel. The judge denied all of their motions. They knew they were going to lose the trial on the facts of the case, and he thought that there was a good possibility of being put to death. And so that's why he took a plea deal. It provides certainty. It provides some sense of closure, and no one will ever be happy. My heart goes out to all of the victims' families here, but they will never get the justice that they rightfully deserve. But as I've said in the past, if you want justice, courthouse isn't the place to do it. Now, what I did appreciate was the judge telling everybody to back off, and he wasn't going to be persuaded by public sentiment in any way, because a lot of the family members that opposed the plea deal, as well as people that were supporters of Kohberger, thought that by calling the judge, that pressuring him to not accept the plea deal was going to work. The judge put a kibosh to that rather quickly, shut it down, and said he's not going to let public sentiment persuade him in any way from following the law and applying the facts to the law. The judge went through it. He accepted the pleas, found that it was knowing and voluntarily made. Now, Frank, the hardest working man in show business, did send me something. It was a show that we did on May 19th, where basically the motions were being denied. Things didn't go well. And I said, I betcha the defense was seeking a plea deal about this time because they knew the end was up. Let's go ahead and open the record for Monday, May 19th, 2025. First on the docket, is there a offer to plead guilty in the Bryan Kohberger case? And you say, well, gee, Scott, why are you bringing that up? Well, let's talk about a little more detail as it relates to the hearing that took place on May 15th for the pretrial conference, right? Called it. I love it when I'm right. I know, I'll hear, oh, you were wrong about Karen Reed, blah, blah. Listen, Karen Reed, I thought she'd been found guilty of the manslaughter charge. Now she's just guilty of DUI. But hey, jury spoken. It is what it is. It's over. Most of the time, the juries get it right. We'll leave it at that. So all the people that say, I'm waiting for Scott to admit that he was wrong. I've said it before. I thought she'd be convicted of it. The jury wasn't convinced. It is what it is. I think if you tried that case anywhere else, 10 out of 10 times you're going to get a guilty verdict, but we'll leave it at that. It doesn't really matter. First on the docket, Bryan Kohberger. Obviously, we know Bryan Kohberger pled guilty, and we'll kind of go via a quick recap, and then let's talk about where he's going to be spending his remaining dying days. All right. So, as you probably know, he has pled guilty as it relates to the University of Idaho murders that go back to November 13th of 2022. Now, Bryan Kohberger admitted that he entered the off-campus residence there in Moscow, Idaho, at about 4 a.m. and committed the murders of the 4 University of Idaho students, Madison Mogen, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle. Now, prosecutors revealed that Mogen and Gonzalez were attacked while they were sleeping in the same bed, and they were killed with the K-bar knife that Kohberger had purchased back in March of 2022. And in the courtroom yesterday, Kohberger, now 30, pled guilty stone cold face cold to 4 counts of first-degree murder along with the burglary count. Now, the prosecutor, Bill Thompson, became visibly emotional as he outlined the evidence that the state would have presented in the trial, describing the murders as premeditated and deliberate. And the guilty plea, which has sparked some mixed reaction among the victims' families, ensures Kohberger will serve 4 life consecutive sentences without the possibility of parole in order to avoid the death penalty by possibly firing squad. And obviously that was the potential if he was convicted at trial, and ultimately the jury decided to give him death. Now, the proffer presented by the district attorney, Mr. Thompson, indicated Kohberger's planning began months in advance. In March of 2022, while living at his parents' home in Pennsylvania, he purchased the murder weapon. By June, he relocated to Pullman, Washington, near Moscow, to pursue his PhD in criminology at the Washington State University. Cell phone data showed his device connecting to a tower near the victim's home some 23 times between July and November of 2022, often late at night. Though no direct contact with the victims was ever really established, and on the night of the murders, Kohberger's phone was powered off, coincidentally, at 2 a.m. just before 5 a.m., coinciding with the time of the killings. Security footage captured his white Hyundai parked behind the victim's home, and he entered through a kitchen sliding door wearing a dark face mask. Inside, Kohberger ascended to the 3rd floor, where he fatally stabbed Mogen and Gonzalez, leaving behind the knife sheath bearing his DNA. On the 2nd floor, he encountered Kernodle, who was awake after receiving a food delivery, and he then killed her. He then entered her bedroom and murdered Chapin, her boyfriend, who was sleeping. Now, a surviving housemate observed a man with bushy eyebrows leaving the scene, and neighbor security footage recorded Kohberger's car departing the scene rapidly. Cell phone records placed him back in Pullman by 5:30 a.m., and he returned to the crime scene the following morning, that morning at 9 a.m., taking a photograph of himself in the apartment bathroom shortly after the aftermath. Now, Kohberger did attempt to conceal his actions. He traveled to Lewiston, Idaho, possibly to dispose of the unrecovered murder weapon in the river. He searched online for another knife, attempting to erase his Amazon purchase history, and changed his car's registration from Pennsylvania to Idaho, specifically because Pennsylvania did not require a front license plate. Idaho did. He knew that anticipated that his car would not have the license plate and would help him be identified. His Pullman apartment and vehicle were found to be meticulously cleaned, with the car's interior described as nearly disassembled. Now, Thompson noted that Kohberger's criminology studies included a paper on crime scene analysis, likely informed his efforts to evade detection. Now, investigators did identify Kohberger through DNA from a Q-tip in his parents' trash, linking it to the sheath at the crime scene. Now, following his arrest, the extent of his attempts to cover his tracks became quite evident. Despite the comprehensive evidence, Kohberger's motive still remained unclear, and his guilty plea may preclude further insight, as he is not required to disclose one. And Kohberger's sentencing is currently scheduled for July 23rd, where he will hear the victim impact statement and have the opportunity to speak, though it's uncertain whether he will obviously choose to do so. He has the absolute right to present a statement in allocution, but it's not going to change anything. So if he's a cold-blooded killer, we know he is, he will more than likely say nothing, not even an apology.